Hello everyone, welcome to Court with Krissy. If this were softball, it'd be a tie game, bottom of the seventh, full count, 2 outs, batter up. I think it's a home run. And at the very end, there's a quick update on the first video from yesterday's forecourt shorts. I hope you like it. Court with Krissy is now in session.
This is the people of the state of Michigan versus Brandy Joe Brown, case number 23-2452 SD. Appearances, please.
Joanna Carey for the people.
Robert Hartel for Ms. Brown joins me at the table, Your Honor.
We are here for a probation violation hearing. Mr. Hartel, what are we going to do?
You would ask for a contested hearing.
Ms. Carey, are you prepared for that today?
I am.
Your first witness.
Melissa Bismack.
Ms. Bismack, you swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yes.
Go ahead and have a seat. And just so the record's clear, we are dealing with a right violation here. That the defendant failed to test on February 25th, 2025, February 27th, 2025, March 3rd, 2025, failed to check in for testing on February 21st, 2025, February 25th, 2005, February 28th, I'm saying 2000, it should be 2025, February 28th, 2025, March 1st, 2025, March 2nd, 2025, March 3rd, 2025. There was a prior violation in which, correct me if I'm wrong, I believe it was 14 technical violations were found.
That is correct.
All right, Ms. Carey, your witness.
Thank you, ma'am. Could you state your full name for the record? Melissa Bismack. What is your occupation? The 84th District Court Probation Officer. Was Brandy Brown assigned to your office?
Yes, she was.
Do you know when?
She was assigned to probation on 8/13 of 2024 after being discharged from sobriety court.
Do you know how long she'd been in sobriety court?
I know she started sobriety court on 10/25 of 2023.
So roughly 10 months in sobriety court.
Correct.
When she was assigned to your office, were the terms of her probation gone over with her?
Yes, they were.
She acknowledged those terms.
She did.
Is part of her probation to do alcohol testing?
Yes, she was to check in every day to see if she has to show up for a random test.
How does she check it?
She can either call in to the site or she can check the website.
Is she taking alcohol testing or drug testing or both?
She is taking both.
Was Ms. Brown, do you recognize her in the courtroom?
Yes, she's sitting in the orange jumpsuit.
Thank you. Your Honor, may the record reflect she's identified the defendant.
It shall so reflect.
Ms. Brown, was she ordered to test on February 25th of this year?
She was, yes.
Did she?
She failed to appear.
And when she tests, if she's called to test, if she calls in and is ordered to test, where is she supposed to test?
She can test in our office, and she has been given other locations to test. I know she had asked to go to Traverse City and New Direction a handful of times. She claims she has. We've asked for verification. We've never received any.
So on February 25th of this year, she did not. Did she report to your office?
She called, or she reported on the 26th of February.
Did she on the 25th?
She did not. When she reported on the 26th, she stated she went to the Traverse City testing location to test, and her card would not work, so she could not test.
Was Ms. Brown ordered to test on February 27th of this year?
She was.
Did she test?
She did not test.
Did she not get to your office that day?
She emailed our office stating that she had no funds to test and was going to try to borrow money.
Received no verification of the test on the 27th.
No verification.
Was Ms. Brown ordered to test on March 3rd of this year?
She was, and she did not test that day.
On February 21st, the allegation that she failed to check in for testing. What does that mean?
That would show our office that she did not call or check the website to see if she would even have to come in and test that day. We remind defendants that it's very important to check every single day so you know if you have to hospital.
How is the probation department notified that someone has not checked in?
We have access to the site and we can see if they logged in and called to see if they have to test that day.
Does someone check that daily?
Courtney, our secretary, checks that periodically to see if people have checked in, yes.
That daily or weekly, or how often do they check that?
We can see it daily. We have access to it.
Did Ms. Brown enter for testing on February 22nd?
She did not.
Did she check in for testing on February 28th of
She
this
did.
year?
She did not.
Did she check in for testing on March 1st,
She did not.
March 2nd,
She did not.
and March 3rd?
She did not.
And between February 21st and March 3rd, were there days that she did check in?
Ms. Brown checked in on February 23rd, February 24th, February 25th, February 26th, and February 27th, and then on March 4th.
Thank you. And again, how often is she supposed to check whether she needs to test or not?
You check in daily.
And she was notified of that?
Yes.
Thank you. I don't have anything further.
Mr. Hartel?
Yes, thank you, Your Honor. Ma'am, you may have partially mentioned this, but were you given any explanation for why she was unable to afford to do some of the testing?
There was an issue with her card at the time and New Direction. She didn't have any cash to pay. Her card wouldn't work at New Direction, so she was unable to afford the test.
To confirm, people aren't able to test with an IOU with a pay later, can they?
Not at New Direction.
Okay. When it comes to some of the other dates, did you have discussions with my client about her being out of town, perhaps a trip to the UP?
She has been out of town, yes, and she has been told if she's out of town, she would have to find a location that would test her, provide verification.
I don't believe I have any further questions at this time.
Ms. Carey?
I don't have anything further.
May this witness be excused? Mr. Hartel?
Yes, you may be excused.
Step down. Ms. Carey, any further proofs?
No, thank you.
Mr. Hartel, any proofs?
Your Honor, my client's informed me that she would like to enact her Fifth Amendment rights, and we do not have any further proofs.
Argument, Ms. Carey?
Thank you. People would ask that the court find her guilty on failing to test on February 25th, 27th, and March 3rd, and find her guilty of failing to check in for testing on these 6 dates in February and March, the 21st, 22nd, and 28th, and 1st, 2nd, and 3rd. I believe the testimony has shown that she didn't test on those dates, nor did she check in on the other dates, and she was informed. She's been on probation long enough to know. And we were just here in January for failing to test violations there's no doubt she knows the rules and what she needs to do. And I would ask you to find her guilty. Thank you.
Mr. Hartel?
Your Honor, at a minimum, I would ask the court to factor in for the failure to test the testimony that was given by Ms. Bismack about how my client had periods where she was unable to access funds. I do realize the court has to weigh in all factors, but I ask the court to not forget that factor when making its decision. If there is a finding of guilt to any of these probation violations, I would, of course, ask to make allocution prior to sentencing, but I'll wait until the appropriate time. Thank you.
Well, the court finds for the standard for a probation violation if the defendant has violated her probation, in that on March 25th, 2025, the defendant was ordered to test and she did not test, albeit she did report on the 26th and indicated the reason for not being able to test was because her card would not work. On the 27th of February, she failed to test and had sent an email stating that she didn't have money. On the 3rd of March, there was a no test. On February 21st, she failed to check in for testing. February 22nd, she failed to check in for testing. February 28th, she failed to check in for testing. March 1st, she failed to check in for testing. March 2nd, she failed to check in for testing. March 3rd, she failed to check in for testing. She was ordered to check in daily for testing as described by Ms. Bismack. And we know that she knew how to do that because on the 23rd, 24th, 25th, 26th, 27th of February and March 4th, she did check in. I find that the defendant is in violation of her probation. And by my count, that brings us to 23 technical violations. I'm sorry?
Today,
Yes.
today's 9.
Total 14. Yeah. Yeah. Have the parties received Ms. Bismack's recommendation?
Yes, Your Honor.
Yes.
Is there anything that needs to be amended in that recommendation?
Perspective.
No, Your Honor.
Elocution, Mr. Hartel?
Yes, thank you. We do realize double-digit violations is substantial. However, I would ask the court to factor in some things that my client has reminded me when I was meeting with her throughout prep for these proceedings. She is a traveling hospice nurse. She does want to make sure to maintain that employment, not just for herself and her long-term ability to be a productive member of society, but also for the people she helps in that profession. She realizes the court no doubt is going to have some concerns when there's findings like this. She would consent, if it makes any difference, to a GPS tether to track where she goes, if that may the court alleviate some of those concerns, daily testing device to take with her. She at the moment may have some additional statements to make herself, but what I would say to the court is she's highly motivated to go above and beyond what she would normally do on probation to make up for the stuff in the past. We do realize also that the fact that she couldn't get to the funds isn't an excuse, but even though there's been a finding of a violation, I do ask the court to factor in the reasonableness of the sentence when it comes to some variables, not all the variables, but some of the variables that were outside of her control. Thank you.
Ms. Carey?
In this case, she pled to operating while visibly impaired. Second offense for blood alcohol at the time was 0.145. In her substance use assessment from September 2023, it states that she used cocaine 2 days before her arrest, that she drank 24 to 30 beers per weekend and possibly a few once a week. She was working on cutting back. We were here on January 22nd, and she had 14 violations, and now we have an additional 9. And in speaking with Ms. Bismack, Ms. Brown is not going, she has not cooperated with probation. She is not doing her counseling, which I think is based on the whole history of this case, she would greatly benefit from, but apparently is not interested in doing so. When people fail to test and don't call the test, from our perspective, that only means one thing, is that they're drinking or likely drinking. And I know we don't have proof of that, but we don't have proof of that because she didn't test. I'm going to ask the court to terminate probation as recommended and do 180 days jail. Thank you.
Ms. Brown, is there anything you'd like me to know before sentencing?
There is. I would just like to point out, I mean, you were here when I was here with Van Alst the last time. Like, I value my sobriety.
With Judge Van Alst?
With Judge Van Alst, yes. I value my sobriety. I've been sober for 613 days. I have not drank. I have a very demanding job. I coordinate home care, hospice, a job that's chaotic, sometimes allows for not being able to get a 2-hour window when I don't even work in this county. So the fact that the responses have been inconsistent, the way first I was told to call, then I was told to email, then I was told you can't email, you have to call again, calls don't get answered. And the weekend trip was softball with my daughter that I also coach. So I'm more than willing to wear the tether so that way there's no doubt, there's no room for error. And I had therapy scheduled, but I got put here for 9 days. In the meantime, I actually attended group therapy with Healing Private Wounds and would like to see Adeline through there instead of Cuddleback, who Melissa Bismack has recommended. But I had therapy scheduled, so I never said I wasn't going to do it.
Anything else?
Thank you.
Ms. Brown, why do you think you're in any different position than any other probationer who has jobs that require them to do things?
Because there's such a, like, my job sometimes isn't just a day shift, it's the night shift, it's on call for the week straight. So it's not just a 9 to 5.
Out of the 300 we have on probation, do you think you're the only one in that position?
No.
I have considered this case quite a bit because, to be honest, this case truly bothers me. I remember when you were in sobriety court, you were violated in sobriety court. You weren't paying your fines. You were ordered to do an essay. Then we caught you driving and you were sanctioned for that. We increased your review hearings. Then a team member observed you driving and you, as is your right, withdrew from sobriety court, and then you were placed on probation. As Ms. Carey indicated, we were here in January when you were with Judge Van Alst, and you were found guilty of 14 technical violations, and Judge kept you on probation. You failed to test on October 7th, October 15th, November 13th, November 26th, December 2nd, December 3rd, February 18th, I'm sorry, December 18th, December 26th, December 30th. You failed to check in for testing. You failed to enroll and provide proof of counseling, although you say you're doing that now. You also failed to provide proof of AA or NA attendance, and you failed to enroll or verify in the alcohol safety education class. Now we're dealing with the violations we have today, which is more repeated behavior, that failed to check in and failed to test. I show that you've made absolutely no payments on this case since 2023. As I said, you've been violated in sobriety court for fail to follow those rules, and now we're here again for fail to following the rules that were put on you for normal probation. You were given a great opportunity to be in sobriety court. I realize that does have some additional requirements to it that regular probation doesn't, and it was certainly your right to withdraw from the sobriety court program. When Judge Van Alts took the plea, she had indicated, at least I think it was taken as a PBT back in September, and the PBT was a 0.13. And now I'm hearing today that the official blood result was a 0.145. This is your second drunk driving, with your first happening in 2020. So roughly 3 years before before you picked up this operating while intoxicated. I know you say that you haven't been drinking, and I'll be honest, I would like to believe you, but unfortunately you haven't been testing, so I'm left with the presumption that you're not testing, and that only means that you're drinking alcohol. Nor has there been, I mean, correct me if I'm wrong, Ms. Bismack, but it seems like she's not tested more than she has tested. Am I correct on that?
Correct.
I think we have extended every possible option that we have to help you, Ms. Brown, and it feels like every step of the way, there's always something more important. And I'm not diminishing the fact that you're a mother and that you have softball. But I do remember an essay that you wrote in which sobriety was third on the list. I feel as though the probation department and the courts are putting in more work than you're willing to do for probation. So I am going to terminate probation unsuccessfully, preserve fines and costs. What's our total credit days so far? Or is it 10 on this?
10 total on the case.
I understand the recommendation is 180 days, but Ms. Brown, the only way I can keep the people safe is if I lock you up for the maximum, 365 days. Your sentence will be 365 days with 10 days credit. That's all. Okay, we are back on the record on the case of the people of the state of Michigan versus Brandy Jo Brown, case number 232452 SD. Ms. Brown, because I sentenced you to jail yesterday, I should have advised you of your appellate rights, and I forgot to do that. So I'm bringing you back today in order to do that. Because you were sentenced to a term of jail yesterday, you have 14 days in which to request the appointment of an attorney to assist you in appealing if you decide to do that. Now, I've also been given a kite from the sheriff's office indicating that you are requesting appellate paperwork. Is that correct?
That is absolutely correct.
Okay, we will go ahead. My staff will start that process. You will receive some paperwork for us to fill out to start that process, okay?
Perfect. Thank you so much.
Yep. Mr. Harrison, anything else before we leave? Okay.
No, you're good.
All right, we're good, Jail. Thank you. Can I have Mr. Truax, please?
Ready to go through the same thing today? I'm not cooperating with you.
I wouldn't expect you to.
Good.
Yesterday, we got through the arraignment of Mr. Japkis. I believe we, based on my review from what I looked at last night, we got through the reading of the complaint. The defendant acknowledged that he understands the charges and the potential
I didn't know
penalties.
shit,
We got
motherfucker.
we got through the point where he had indicated that he requested an attorney. The court will make a request for an appointment of an attorney, will enter a not guilty plea on the defendant's half, will set the matter for a preliminary examination. A preliminary examination is a hearing that's held here in the district court within 21 days. At that hearing, the prosecution is required to prove two things: one, probable cause that these crimes had occurred, and two, probable cause that the defendant had committed the crime. If the prosecution is not able to do that, the case would be dismissed. If they are able to do that, he'd be bound over to stand trial in circuit court. The only thing that I believe left to do is to set bond. Historically, I show the defendant has a domestic violence in 06, an aggravated stalking, and an attempted home invasion first in 06, in 08, a domestic violence, In 09, in the domestic violence. In 09, a stalking. In 10, a CSC second. In 15, a failed to comply with SORA. In 19, an attempted interfering with electronic communications. In 21, a disorderly person. In 22, an assault and battery. In 22, an operating without a license on person. Corrections, you can put him back in his cell if you need to for your own safety. I find good cause to do that. We will continue with the bond hearing. In 22, an attempted assault and battery. In 23, a resist and obstruct, along with a trespass. In 03, a drug case that was pursuant to a diversion. I show he has a failed to appear warrant out of Ludington from 23, and a failed to appear in 24 for a child support case in Saginaw. Mr. Harrison, anything regarding bond?
Given his current demeanor, I don't know that it would be appropriate to even request a PR bond. Obviously, we're going to be inquiring as to his competency and that sort of thing, perhaps down the road.
Jail, you are, they're free to go, right? Jail, you're free to go. Thank you for your patience today.
Thank you.
Ms. Carey, anything regarding bond?
Your Honor, the people would ask for a cash or surety bond. I believe that he's homeless, that he's not employed. He has several peers in the past. Behavior certainly is concerning over the last couple of days in his anger. So PR bond is appropriate. Or frankly, anybody else.
Was the resist and obstruct, can you describe that a little bit? I mean, was that a hands-on resist and obstruct, or was it just more failing to comply with orders?
Started out, the officers were looking for a suicidal suspect, and they asked him for somebody else. He became belligerent and yelling at them, and he tried to continue on, and he kept disrespectful, and then he wouldn't stop, and he wouldn't leave them alone, and it escalated from there. So was taken to the ground. It's like,
All right. Well, the court finds, based on the defendant's actions, 2 times we tried to do the arraignments yesterday and his actions today, along with the recitation of the facts given, or the allegations given by Ms. Carey. I find that the defendant is a threat to the community. I also find, based on his fail to appears out of Ludington and Saginaw, that he is also a flight risk. If I recall correctly, based on a sidebar yesterday, Mr. Japkus may have been receiving community mental health at one point as well. I'm going to put a cash or surety bond of $10,000 in place. Defendants to appear as ordered, keep his contact information current, not leave the state without permission, and commit no crimes. I'm also going to order that he work with community mental health, and that he also follow through with any medical requirements that he has. Anything else, Ms. Carey?
no, thank you.
Mr. Harrison?
I think that covers it, Your Honor.
Thank you.